Hey everyone, how are we? What's going on this afternoon? Hi everyone. Okay, I got to go through. There's too many of you guys. I can't even go through this to see how many to say hello to everybody. It's horrible. There we go. My screen was a little messed up. I couldn't see. Hello from Texas. Yeah, I wanted to come on early for a couple of reasons. Number one, I just like to say hi to everybody. And number two, I also wanted to kind of play some, I don't know, I pulled some stuff out of the archives for you guys. Now, these aren't the best pieces of the trial. These are just little things that will, oh, it'll bring back the memory of good old Daffy. What did I call him? I can't even remember. Scooby Doo and, Scrappy Doo. You're here for the DB slander. Girl, we're going to have it for you, baby blue. It's good to have you back. A lot of people I haven't seen in a while. Hi, Mandy, Teresa, Mel, Daryl Maxwell from Kansas. How you doing? Fly Girl, welcome back. Charlene, Mr. Steve, number one on the inmate dial. That's right, 906.11. Hey, Miss JPC. Bama, what's up? Spider Man. Paula? No, Paula, it hasn't started yet. It actually does not start till 2 o'clock, but I like to come on early. Because while I'm trying to get the background about what we're trying to watch set up, I've just got something to play for you guys that is something a little special. Hi, Anne. Too many preliminary hearings. I know. I know it. The last time we saw him on Zoom, I was like, oh, what happened? Ooh, jail is not doing him well. Hi, Linda. Miss Amanda Page. Chi. Did I miss anybody? Debbie. Peepla. What happened? He screwed up. All right. Okay, so Peepla, before he was arrested for his trial over in no, we're talking about Daryl Brooks, obviously. Before he was arrested for what he did to the Waukesha people at the parade, he had actually gotten in trouble for a couple of other things. So that's what we're here today. They're still going through with these charges on him. And the reasoning is that which a lot of people think that it's just waste of taxpayer dollars, but just in case his appeal comes through, something happens with that, they want to have a backup plan so that this little monster never gets out of jail ever again. And yeah, Mandy, we're kind of anticipating him saying pro se, but you know what? I found out something very interesting that I wanted to tell you guys about. Let me pull it up here. So first of all, what we're looking at today is the pretrial. This is the final pretrial for his June 26th hearing, which we will be on that as well, or the trial. So we'll be back on June 26th again. Um, the other case that so he's got three different ones, but I think two of these are put together. So the ones that we're looking at today are based upon intimidation of a witness and intimidating victim or threatening force. The additional case that was added was for resisting or obstructing an officer, bail jumping, second degree recklessly endangering safety in related to domestic abuse, disorderly conduct in related to domestic abuse, and battery in relation to domestic abuse. Um, this is the female judge, Judge Michelle Ackerman. Is it Havas? 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 I'm going to go with Havas. That sounds better, right? And these charges were filed on December the 6th of 2021. So technically they were charged after they started the other one, but um, he did these things. Erica has charged him for these things, so they're gonna let the victims have their day, I guess, so to speak. Now, the other trial that he has, that one is going to be on July 10th. That trial will be on July 10th. That one was filed in July of 28th of 2020, and those were for the charges against what I believe his nephew and his mother, where he recklessly endangering safety by using a dangerous weapon, possession of a firearm as a uh, felony, as a convicted felon. Um, Now on March 23rd, in that case, the one that'll be in July, the defense informed the courts that he had previously filed a motion to withdraw his counsel and that it was no longer pending, and they do not want to address that with the court anymore. So basically, defense informs the court that the previously filed motion to withdraw his counsel is no longer pending and does not need to be addressed by the court. That was on that case. This case over here we're talking about with Erica, haven't seen anything like that on that. So we don't know. Is he going to come in today at the last minute and say he wants to go ahead and uh, defend himself again? I mean, we know how that went the last time, right? So it's going to start in about 20 minutes. So I wanted to play something for you guys while I'm playing this. You guys can enjoy some old archives, and I'm going to be in the background making sure that when it goes live, we are there and for it. Okay?
Those findings, so we will go.
Welcome back, Mr. Brooks. Please be mindful, sir, that the right to be here can, of course, be lost if you engage in disruptful, discourteous behavior, if you interrupt the decorum and do not show respect for the judicial proceedings. You would, of course, be subject to removal and forfeiting your right to be present in this courtroom. I know you're holding up your objection sign, sir, but I am giving you the opportunity to come back over here. Would you like to come back to this courtroom? Record should reflect he's holding up his objection sign. It appears that he's writing, I don't know what, of course. Mr. Brooks, I'm going to ask you again. Would you like to come back to this courtroom for opening statements?
So I'm on the record.
You are. If you would please address my question.
So you want me to come back over there just to get brought back over here?
That's not what I asked you, sir. I told you, I advised you, I would like you back here. It's always my preference that you're here. So my question to you is, do you want to come back to this courtroom, sir?
So I can get sent back over here, because as soon as I say something, I'm going to get sent out.
Mr. Brooks, it's your conduct in this courtroom. It is what dictates the court's response.
You say that even though I never consented to being taken out. You say that everything is about the decorum and all this. That's what you say. But when I'm raising issues of understanding, which I keep telling you I don't understand, then it's looked at as being disruptive. It's looked at as intentionally trying to be disruptive. Nobody reported on record about me being bruised up and having to get bandaged up and all these things, but it was put on me, laid at my feet, as if me, quote unquote, being disruptive was deserving of what happened to me. Do you see these boxes I got right here? Do you think I was able to go through everything in those boxes?
Mr. Brooks, I'm not going to go through this with you again, where you attempt to put on the record all of these issues that you have when we're in the middle of a trial. All right? You willingly waived your right to an attorney. I made all of those findings, so we will go
You made
forward.
those findings,
I
but
am
the-
not obligated to answer questions.
made
When you
those
ask me
filings.
questions, I'm gonna mute him.
Motions to address that are based in law and fact. I'm obligated to address objections, for example, whether it be to back to this courtroom, and he chose not to answer it, but instead he's muted. The record should reflect. It appears he's talking as well. He's making hand gestures. His lips are moving behind the mask, and I just wanted to make a record of that. That's a multi-count instruction, and so that's why you gotta look back.
I'd like to go back over there, Your Honor.
You would like to, you're asking that to voluntarily be taken to that courtroom.
Can I at least raise the issue of subject matter jurisdiction? That's
No, there's no lawful motion before the court. You may not.
All right, why don't we print that off so that Mr. Brooks can review that as well.
Seem to being called that name. And what do I need to be reviewing?
The state has submitted an alternate proposal for instruction 152.
And that's referring to this quote-unquote jury view?
Yes.
I accept for value in return for value this document. Now, I'd like the record to reflect, I still haven't received my original copies of my filings here this morning with the timestamp.
Let me know when you've had an opportunity to review it if you so choose.
I just stated for the record, I accept for value in return for value the document.
Do you have any position on this state's proposal?
I'm still trying to understand the whole process.
Mr. Brooks, my question to you is, do you have any position on the state's proposed jury instruction? Otherwise, I'm going to rule on their request.
You're gonna rule on the request anyway. I got a lot of questions that don't get answered.
I have to rule on the request, sir. It's been a proposal filed with the court.
You haven't ruled on subject matter jurisdiction yet.
Yes, I have.
No, you
In
haven't.
any event, do you have a position on the jury view, sir?
Yeah, what about subject matter jurisdiction?
One last time, Mr. Brooks, do you have a position on
Can
the
I
state's
go over the
proposed-
document, please? Can I do that, Your Honor? Respectfully
sorry?
for the record, may I do that? You seem like the same thing that was there yesterday.
It's not. There are some changes.
What changes?
Reference
It's
to
the same.
the-
It's the same document that was
Reference to
accepted for value,
the-
return for value yesterday. The same document.
It's not the same. The changes were put on the record verbally by the state. It's taking out reference to Sallyport of the Waukesha County Jail, referring to it simply as a garage attached to the Waukesha County Courthouse.
All right, good morning, everyone. The court will call State of Wisconsin versus Darrell Brooks, case number 21 CF 1848. And the defendant, Darrell Brooks, appears in person in custody. I'd also like the record to reflect that he is appearing in jail attire today. He's also wearing a mask.
I object to that, Your Honor. I do not identify by that name and would like the opportunity to state that I'm here concerning this matter as third-party intervener in this matter, appearing as authorized representative for my client. I accept for value in return for value all the charging instruments in this matter and make my exemption available for discharge of all obligations and charges connected with this case. I do not dispute any of the facts in the charging instruments and would like to now reserve my rights, if I may.
Mr. Brooks, you just interrupted me within a minute of us starting this case here today. I'm asking you to respectfully not interrupt me. That's the second time, so I can go through the list of things that I need to get through this morning.
I just wanted it stated for the record that
Mr. Brooks, it wasn't the
you
proper
called me by.
time
That's
to
all.
do that. That's now the third interruption. So,
With all due respect, Your Honor,
Mr. Brooks, by saying all due respect doesn't change the fact that you're interrupting me. Your objection is noted, all right? But you need to stop interrupting me so I can get through what needs to be done.
But it is my
I have a
right
number
to-
of documents
it is
that I
my
need
right
to discuss
it
this
is
morning.
My right to,
Mr. Brooks, you do not have a right to interrupt the court.
No, it
I
was-
will
that
remind
was
you
not
once
my
again
intention.
of the Supreme Court rule. It's on a yellow laminated, double-sided piece of paper that is before you. I
did not
checked, I
recognize
verified,
that.
it
I
is.
accepted and returned it for
Mr. Brooks,
value,
that's
Your
yet
Honor.
another interruption. Let me get through this, please.
I just want, for the
You will
record,
have an opportunity when I give you an
I want
opportunity. No
to
one
state
else
it.
is speaking at the moment but me. You need to stop interrupting.
I don't identify by that name.
Mr. Brooks, I am going to keep going. You are warned. You need to follow the standards of courtesy and decorum for the courts of Wisconsin. Chapter 62, that's another interruption.
I intend to follow decorum.
This court comes with a history of Mr. Brooks interrupting now. This is day 4, and every day Mr. Brooks has interrupted. It has resulted in Mr. Brooks being placed in a neighboring courtroom so that this court can efficiently, effectively, and with dignity preside over this case here today. I am well aware that's another interruption. I'm well aware. Stop
respectfully, which I have the
talking.
right to do.
I'm well aware, Mr. Brooks,
I
that
have
you
not
object to the
intended to
name that
cause any,
has
disruption.
identified on the information and all documents in
wanted
this
noted
case.
for the record
Your
that I
objection
did
is
not
noted. It
identify
does
by
not
that
need to be
name.
repeated. I will make a record right now. The
May I
court
have the
notes
opportunity to
a
preserve my
continuing
rights, Your
objection
Honor?
by Mr. Brooks of his name and that he objects to being here. I know he's filed a number of documents previously
I never
related
objected
to
to
that.
being
Those
here. I just
documents
state-
are
I tried
of
to
record.
state
There's
that
another
for the record,
document
Your
that's
Honor.
filed. At least 2 more interruptions just now. I believe I'm up to 8. Mr. Brooks, you're advised that continued interruptions will result in you forfeiting your right to be present in this courtroom, where you'll be taken to the courtroom next door to appear by video and audio
I don't
means to
consent
participate.
being removed from the courtroom, Your Honor.
That's another
And you
interruption.
haven't shown me any lawful case law that I can be removed from the
Mr.
court
Brooks?
proceedings in a trial and forced under coercion and duress to appear in the trial that I am needed, that I've tried to express that I have the right to
Mr.
be
Brooks, there's a
present for.
proper manner in which you raise objections. You have not followed that proper procedure. You are unable or unwilling to abide by simple rules of civility.
You haven't
You
given me the
interrupt,
chance to
you don't wait for
state my
anyone
name.
to finish, and it will result with you being removed from the courtroom.
I
So
respectfully
you are,
object to
once
that, Your
again,
Honor.
because this court has taken a number of steps to shield from this jury that you are in custody. Your hands are not shackled, okay? There are skirts around
feet are
each
shackled.
one of the tables. I'm aware of the feet shackles. That's yet another interruption. I would like you to appear in street clothes, and the reason why, sir, is to reduce or even eliminate even the appearance that you are in custody. And it is your choice, though. Are you willing to go back to your cell and put on your suit?
It is my right to do so or to not do so. And at this point, Your Honor, who doesn't know that I'm in custody?
Again, it is your choice. Are you willing to go back to your cell and be dressed in the street clothes that you previously appeared in?
With all due respect, I do not agree with that assessment whatsoever. There's no possible way that anybody will not know that I am in custody. I think that's a well-known fact because it's reported on every day in the media. It's shown every day on the news where I am, what jail I'm housed in, and that I'm in custody. It's virtually impossible for anybody to not know that I'm in custody.
Mr. Brooks, did you hear the question that I asked you?
And I respectfully keep the position that I just put on the record.
Mr. Brooks, I will ask you again. Are you willing to go back to your cell or into the jail and put on street
I
clothes?
do not consent or agree to anything that you just stated, Your Honor.
You refused to answer my question about
not
whether
refuse.
you would
I answered it.
go
You just
back
didn't
to the
like to
jail.
answer
That's
it.
another interruption. So based on his refusal and his
I did
choice
not
to come,
refuse.
that's
I did
another
not consent
interruption.
to saying
Based upon
a
his
refusal. I answered.
failure to answer my question directly, I will
I
take
did
that
not
as
refuse.
a non-response, but he came to court
That was
here
not a
today. That's another
non-response, Your Honor.
interruption. I will take that because he's come to court here today in his jail attire, that is a choice that he has made freely, voluntarily, and intelligently. No one has forced him to come
I
to
did not
jail in
consent
those
to that.
clothes. This court is encouraging him not to. He's appeared previously in his street clothes in what I would describe as a very suit and tie, but it is his choice to not do that, and we will proceed accordingly.
So while we're on the record, may I challenge the subject matter jurisdiction?
No, you
of
may
the
not,
court?
sir. You need to file a motion in order to that.
So
Mr.
the
Brooks?
motions I filed haven't even been responded to. I gave
Mr. Brooks, you're
3-day
interrupting me
No,
yet
you
again.
just weren't speaking,
All right,
so I didn't
Mr.
interrupt.
Brooks, you are now going to be removed to the
I
other
don't
courtroom.
consent to that.
I have
I am
had
under
a
duress
dozen or
by
more
having
interruptions.
shock- I
We'll
have
be
shock-
off the record while
shocks
we do
on my
that.
ankle.
Thank you,
I don't
everyone.
agree to a stop. Well, I move for a motion to dismiss for being under duress and being coerced into a contract that I did not consent or agree to. I do not. I have a right to be present for trial.
939.50 sub 3 sub A and 939.63 sub 1 sub B of the Wisconsin statutes. The sixth count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street, and while using a dangerous weapon, contrary to section 940.01 sub 1 sub A, 939.50 sub 3 sub A, and 939.63 sub 1 sub B of the Wisconsin statutes. While the law requires that the defendant acted with intent to kill, it does not require that the intent exist for any particular length of time before the act is committed. The act intent should not be confused with motive. While proof of intent is necessary to a conviction, proof of motive is not. Motive refers to a person's reason for doing something. Sir, would you please state your name for the record?
I'm here as a third-party intervener in that matter, appearing as authorized representative for my client. I accept for value and return for value all of the charges instruments in this matter and make my exemption available for discharge of all obligations and charges connected with this case. I do not dispute any of the facts in the charging instruments, and for the record, I do not consent to being called that name.
The record should reflect that the individual known to this court as Darrell Brooks is present in person in custody. He is in street clothes, wearing a suit and tie and a mask.
I don't consent to being called that name, Your Honor,
I understand,
for the
sir.
record.
And I have advised you previously that I will continue to refer to you at times by that name, as I believe it's appropriate given the charging instruments in this case. And other evidence now that's been received during the course of this trial where I believe we are using the accurate name. With that, I
don't agree to that, Your Honor, or consent to that.
your lack of consent is noted. And the jury will be brought out and you'll be asked to call your next witness.
For the record, I don't consent to being called that name.
So noted.
And we still need to address subject matter jurisdiction before the jury's brought out.
I will not be doing that.
Will it be proven for the record?
The record stands.
So is that a tacit agreement that you don't have to answer that question, Your Honor?
I make no such agreements with you, sir.
So that means you can answer a question then. Will we be addressing subject matter jurisdiction on the record, and will it be verified and proven? Non-responsive answer is a tacit agreement, Your Honor.
Jury's coming out.
And do you recall being informed that it was a possibility that you would be testifying in this matter?
No, I did not know that.
Were you subpoenaed at any time?
Yes, I was.
And do you recall about how long ago you received that subpoena?
Several weeks ago.
So pretty recent, would be fair to say.
Yes, I would. Well, several weeks ago. I'm not sure if that's your definition of recent or not, but
Do you recall who served you the subpoena?
Objection relevant.
Grounds.
Overruled. The witness may answer.
the district attorney's office from Waukesha.
Do you recall if it was a specific district attorney?
I do not recall.
Do you recall if you were contacted by the plaintiff in this matter?
Objection.
Grounds.
Vague.
Sustain this to the form of the question.
Do you recall having a conversation with the plaintiff?
Objection.
Grounds.
Misleading, legally inaccurate statement. Your Honor.
Grounds.
Sustain this to the form of the question.
Do you recall having a phone conversation with the plaintiff in these?
Same objection.
Grounds.
Sustained as to the form of the question.
Do you yourself recall reaching out to the plaintiff in this matter?
I'm not sure who the plaintiff is. Can you define that for me?
The plaintiff would be who's bringing the claim.
Your Honor, I object. Well, I realize there's no question at this point, but if he's going to ask the witness to answer his prior question, now that he's clarified this is irrelevant questioning.
We'll see what his question is first.
I asked it.
Please ask your question again so that I'm clear.
Have you yourself ever reached out to the plaintiff in this matter?
And my objection is it's vague and it's legally inaccurate.
Sustained as to the form of the question.
Do you even know if there's a plaintiff in this matter?
Objection
Grounds.
argumentative.
Sustained as to the form of the question.
Have you yourself filed any complaint in this matter?
Objection
Grounds.
irrelevant.
Overruled. The witness may may answer, sorry.
I have not, no.
Do you know of anyone who filed a claim in this matter?
Objection
Grounds.
irrelevant.
Overruled. The witness may answer.
I do not.
Well, that was that. I thought that'd be fun to watch while we waited. Still waiting. A few minutes ahead of time. Did you guys have a nice weekend? The court stream is not up. It's not going. So I've got other avenues that I've checking here just to be on the safe spot. A couple of different live streams I've got going in the background. Now remember the last couple of times that we've done this, they didn't come in till late. So it could just be that they're running late. I know that Fox 6 was in the courtroom earlier today on another case that I see here. Third birthday. Coffee cake, why'd you put motion to adjourn? Case. Well, I got that case pulled up. Oh, I see what you're talking about. Motion to adjourn. Okay, coffee cake. So are you saying it's not going to happen today? Why would they do that? I do not consent to waiting. I don't either, Mark. I do not consent to that. Because I had everything pulled up. Dad, blast it. No wonder it's not coming up. Well, that just blows. I'm glad Coffee Cake brought that up because I didn't realize it. When did they? Obviously, they filed it today. Doesn't mean. Don't be sending people to other places on my channel on YouTube. I'm not gonna stream another person's stuff on here. That's not cool. Yeah, I just don't think they're gonna. uh, So if they motion to adjourn, does that mean there's a couple of things that could be happening here. He could be he could be giving them problems again. I don't think it's Erica. I think it's him. You're hearing wheezing. You're hearing my dog, people. So they're not. There's nothing on the court site yet that says that they're rescheduling it. Y'all see, this is why I hate live streams. Okay, hit it. Hang on, I just refreshed it. No, it doesn't say anything else. Hmm. But this was just a pre-trial hearing. Maybe they felt like they don't need, they had, maybe they didn't, because the defense had requested the final pre-trial. So maybe they feel they didn't need the pre-trial meeting hearing. Gotta get my court lingo on. Rubs to pups. He always my puppy always makes so much noise when I'm on stream, and he always comes and sits right next to me when I start talking. It never fails. The trial is scheduled. Okay, so let's go back to the trial scheduling so you guys can understand what's going on there. We got two different trials, okay? This trial is set for June 26th, and the charges on it are the intimidating a witness, intimidating a victim, threatening force, and also the second it's like two cases in one that they're trying together. And the second case is resisting or obstructing an officer, bail jumping, second degree recklessly endangering safety in regards to domestic abuse, disorderly conduct in regards to domestic abuse, and battery in regards to domestic abuse. Um, these charges were filed in December 6th of 2021. And again, the trial will begin on June 26th at 8:30 a.m. And yes, we will be here for it. So I hope you guys will be tuning in. Now, this other trial, is scheduled for July 10th. That's with the male judge. I think his he pronounces it Feist, Judge Feist. And they're two different charges. There's two separate charges for second degree recklessly endangering safety, using a dangerous weapon, and that was the whole gun thing with his mom and his nephew. And then also possession of a firearm because he probably wasn't even supposed to have a firearm because he's a felon. On March 23rd, the defense informed the court that the previous motion filed to withdraw as counsel is no longer pending and does not need to be addressed by court. So that was, again, he had stated he was going to try to represent himself, but I guess he pulled out of that. Maybe they just talked him out of it, you know? And those charges were filed in July of 2020. So, yeah, I think it's like I said, I had other streams pulled up because I wanted to, just in case we had a problem with the Zoom or something like that, if a news station was putting it up, we would be able to watch it. But and Fox was there this morning looking at another case. Actually, Fox and Wisconsin News was also there on that same case. Nobody's streaming anything about Darrell, so obviously it was canceled. Um, that just blows. I mean, I guess we could wait a little bit though, because you know how it happens in the courts. We could be waiting and then something else comes up. I don't want to jump off too early. So, what other cases, while I've got you guys up, what other cases are you guys interested in? We're going to be looking at Suitcase Sarah, because, that's just a crazy case. Bless her heart, she can't find anybody that wants to work with her. That's why they have to keep delaying the trial because they can't find any doctors that want to do anything with her case. They say it's a money thing, but it's not just a money thing. Hmm. Well, and another thing I found odd too, you guys, is that I have pulled up. There's two different things for Wisconsin. There's that live stream Zoom thing they have, and then they have that other site where they stream. I forget what they call it. Wisconsincourts.gov. And no branch. I went through each branch and none of them were streaming today. And I thought, well, what? That's weird, because I figured they'd have something on, but nada. So just let me read your exactly, people, and no one wants to put their reputation on the line for her. Yeah. Welcome back again, Tina. The judge or the defense filed a motion to adjourn. So Spider-Man said, "Yeah, we want Sarah Wackadoodle." Y'all are watching the OnlyFans stuff, and Brian Cole. Everybody's watching Kohlberger. That's what I was thinking, Tina P. It's been this every time they've started. It's been really late. So, do you think? Well, it doesn't. Wouldn't it say though? I'm gonna let me refresh the thing and see if they've put anything else on there. No, they've put nothing else on there for today. But here's the thing, in a pretrial meeting, they don't have to have it, right? That's what I'm thinking. Frankie, why are you panting? My viewers do not appreciate your panting. And don't look at me like that. They do not consent to that, Frankie. Okay, well, doggone it. I was excited too because I wanted to see something happen today. You know what I was thinking though, as I was getting ready for this? I'm like, I've got to put some more videos out. I promised y'all I would, and I haven't done it. When? How did you find that out, Carrie, about the defense motion to adjourn? Teresa, it's on their website. It's on if you go on to the Wisconsin courts.gov site, you can look up the cases. And see, that's what I was thinking. I don't think they have to have a pretrial. Maybe they just realized they didn't need it, so they're not going to have it. I'm not going to get off yet, though, in case they do have it. Battered wife, but there's no way to prove that when they see the video of the zip from the suitcase. Sheila, or I'm sorry, Shelly says, I have never seen a case where a defendant has went through 7 lawyers and counting. I know she's been through a lot. Well, I mean, if you got her case and then you saw her interrogation and that video, the video where she basically screwed herself. She has a video, if y'all don't know, we're talking about Suitcase Sarah. She has a video of herself basically fussing at him, saying, yeah, this is what you get. This is what it feels like. And she's laughing. You can tell she's drunk off her Botox. Oh, I know. Well, I tell you what I'm gonna do. I'm gonna keep a lookout. If I get any news on this, I'll post a vid. If I might come back on, I might come back live. Just depends. Um, but I hate to keep you guys waiting. But then watch, we'd get off here, and then all of a sudden it'd be back on, right? That would be my live streaming luck because I'm horrible at live streaming. I like trials where it's just it's coming on. But I mean, there's nothing, guys. All right. Well, if I tell you what, if it comes back up, I'll have to come back on. Sorry to keep you guys waiting without saying anything. Okay, let's see. Is anything else? No, nothing else has been put up. And I wonder what time that was put up too, because I just looked at that earlier today. Oh, let me go to the court. Let me go to this other case that's connected to it. see what it says on that case. Defense motion to adjourn filed. So they could still be doing some stuff, but who are you talking to? Just hear me out. Who are you talking to? Mr. President Darrell Brooks. We're talking about Oh, thank you, Teresa. I appreciate you. Yeah, we tried. It'll happen again. Oh, you're doing your Brooks impression. Okay, just hear me out. I was like, who are you talking to in the chat? That's funny. Oh well. Okay, look, guys, this other one I'll post again when it comes up, and I'll be on that one. I'll also be on that trial too. I got to make sure that this Sarah Boone trial and Darrell's trial don't interlap in any way because I mean, let's take a quick vote here because you guys are the diehards. You're still here. If you had a choice between watching Darrell's hearings, Milwaukee hearings, and Suitcase Sarah, which would you pick? I think I know the answer to this, but I'd be really interested in hearing what you guys think. All right. Brooks. Brooks. Okay, so Brooks wins. Oh, just hear me out. Says Suitcase Sarah because Brooks didn't do anything at his last hearing. Oh. Oh no. Steve. That's funny, Steve, but I can't say that. Well, that's what I was wondering. Just hear me out. I was wondering, did he put in for the pro se thing again? Is he trying to defend himself? And that's why they're like, okay, we're out, And does that are they sitting in the courtroom right now? But I think even if they were sitting there trying to, figure out what's going on and have their little private meetings and sidebars and all that, I still think somebody would be streaming this, which makes me think they're not even there right now. They're not even in the courtroom. I mean, we know that Darrell was coming in on Zoom anyway. But all the news stations that have been watching him closely, none of them have anything up on it right now, which kind of is telling to me. Because there's like 3 of them that have really been following him big time. Sarah's is ongoing, so I guess we could. Well, yeah, Steve is probably right, though. Yeah, you're right, Spider-Man. I just, as entertaining as we found Suitcase Sarah to be at one point, I don't know if her trial is gonna be that entertaining. Like, going into it, we're anticipating this to be just craziness, but it might not be. And we know that usually Darrell's is craziness, but that's when he's defending himself. But we do need the closure, don't we? We need the closure on Darrell. So I agree. Yeah, I'm on top of that one for sure. All right, well that's good to know. I'll definitely stay on top of Darrell for you guys. All right. Well, guys, I want to thank you for coming in today. We did make a try at it. If anything pops up, we will definitely come back. And I'm today kind of, I don't know, it brought me back to a new space. I want to do some more videos on Darrell. I didn't think anybody out there was still doing any, and I didn't want to have bad taste by doing them because I just really wanted to be, I don't know, like my conscience tells me, let it go already. People are tired of it. And, it's kind of mean. Is it the right for the victims to keep putting it out there? But I think there's still so many people that are still, no, you did not. Okay, let me block that user real quick. Um, there's still a lot of people that want to watch it, and there's still a lot to be put out. So I'm going to put some more stuff on. He had an accident. I got him. I got him. Just hear me out. Yeah, I should have put this on subscribe mode only. I'll do that next time. Well, that's what I was wondering, Miranda. Does it have to get approved? But again, they were the ones that requested this pretrial hearing. So maybe they figured we don't need it now for some reason or another. So we're just not going to, we're just going to adjourn it. And so the judge is like, okay, no big deal. You were the one that needed it. We don't need to. I don't need to meet with you unless you need to meet with me. So it wasn't the prosecutor who brought it up. And y'all know I'm not an attorney and I don't pretend to be one. I did not eat my Wheaties this morning and I did not sleep at a Holiday Inn last night. So you come here for the entertainment, not the legal knowledge. Let's just be clear there. All right. Well, I'm going to let y'all, Southern goodbyes are horrible, but I'm going to go ahead and let y'all go for the day. I um and if I see anything else come up, I will go ahead and be streaming again, or I might just put up some more videos of Darrell. So if you haven't already subscribed to my channel, please do so. But these days you got to hit the bell too. You can't just subscribe because if you don't hit the bell, it won't come up in your little notification area when I drop a video. So make sure you hit the bell when you subscribe. Please like this video because you know what? If anything, it's for the effort we put into it, right? And I will see you guys soon. And again, thanks for being here. Y'all have a blessed day.